I think we're just waiting for Jeff.
Is Jeff still?
There's Jeff.
Here he is.
Hello.
Got the cue.
Jeff, thanks for coming. See you.
Hi, Jeff. Okay, if everyone could take a seat, we will jump right into our next discussion. Thank you to all of our panelists and everyone here in the audience and online for joining us today for our second in a series of Open Internet Roundtables. For those of you who are just tuning in, I'm Julie Veach, Chief of the Wireline Competition Bureau. Seated next to me is Matt Del Nero, Deputy Chief in the Bureau. And we are very pleased to be here to moderate what is going to be another very lively discussion about the open internet. The roundtable that we just concluded looked at some of the threats to internet openness and how we can tailor our policies to address those. In this discussion, we'll talk about what types of activities and services those policies should cover. There are three questions in particular we want to focus on that came up in the public comments. First is the topic of reasonable network management. In 2010, the rules that were struck down, the FCC said that activities that otherwise might be prohibited could be allowed if they were a form of reasonable network management. To use an obvious example, while ISPs were prohibited from blocking content, they were allowed to block spam and malware because that was a form of reasonable network management. The question now is how the FCC should define and treat reasonable network management in any new rules. This afternoon, the roundtable on mobile broadband and the open internet will delve more deeply into that question as it pertains to mobile. The second thing we want to focus on is the question of specialized services. Again, looking back to the 2010 rules, the FCC said that this category of services would not be subject to open internet rules, a classic example being an ISP's managed VoIP offering or dedicated IPTV stream. Here again, the NPRM has asked how to treat these services in any new rules. And third is the question of what aspects of the network should the new open internet rules govern. Traditionally, the rules have looked at the practices in the last mile, or the treatment of what an ISP does with bits once those bits are in its network. But following some high-profile disputes earlier this year, a number of parties have called on the FCC to extend new rules to the point of interconnection between the ISP and other networks and services online. We'll look forward to hearing a range of views on these topics in a moment, I'm sure. A few housekeeping items. As in our earlier roundtable, we'll proceed as follows. First, we'll introduce the panelists and ask each to give a 3-minute overview of their views. Matt and I will then pose questions to the panelists and also incorporate questions we've gotten from the public via cards, emails, and tweets. We encourage all of you who are here in person today to submit questions to the moderators by filling out a note card that will be collected by FCC staff. And if you're participating online or if you're here in person, you can also submit questions by email to the address up on the screen, roundtables@fcc.gov, or using Twitter using the hashtag FCC Roundtables. At the conclusion, we'll have an opportunity for any questions from the chairman or any of the commissioners present, and more public comment and public questions through the means I just described. One important note for the audience, both those here in person and online, by submitting a question, you'll be making a filing in an official FCC proceeding. All information you submit, including names, addresses, and other personal information, will be publicly available online. I'll now turn it over to Matt, who is going to introduce our distinguished panel.
Great. Thanks very much, Julie. And one thing I just wanted to add on behalf of Julie and myself is a word of thanks to folks who helped bring the roundtables together. There are many of them, but one in particular is Christine Fargetstein, who is an attorney in our competition policy division and really helps make all of this work so that Julie and I can sit up here and look pretty, or at least Julie looks pretty, and I don't know. I try, but try to at least keep my tie straight. But thank you to Christine, particularly for all her work here. Now, in introducing the panelists, we're going in alphabetical order here, and we, for some reason, have a panel, although I think is fairly balanced in terms of views, is tilted to the end of the alphabet. But we have organized...
That would be reasonable.
Reasonably,
panel
yes.
management,
It is a
in my
reasonable
view.
panel, absolutely. So to my left, alphabetically, Jeff Campbell, who serves as Senior Director, Technology and Trade Policy with Cisco Systems. And Cisco is one of those companies that really is at the heart of the Internet. But as an average user, you might not think of it very often. But they make a lot of the equipment that is helping the Internet run. So certainly bring an important perspective here today. Daniel Pataki, he gets the award, first of all, for traveling the furthest to attend our Open Internet Roundtables. So we particularly want to thank him for traveling from Brussels to be here. He's Executive Director of the European Telecom Network Operators Association, or ETNO, that has been very active in the discussions around net neutrality rules in Europe, and where specialized services, among other issues, have been a hot topic. And he also has a distinguished background as the former president of Hungary's National Communications Authority. John Piha is a professor of engineering and public policy at Carnegie Mellon University in Pittsburgh. So traveled far, just not as far as Brussels. He served previously as chief technologist of the FCC and was also an assistant director of the White House's Office of Science and Technology Policy. In addition to his government service and his scholarly background, he also had time in the private sector as chief technologist at a number of high-tech companies. So wears many hats today. Matt Wood is a policy director of Free Press. And Free Press, as you may know, is a nonprofit organization that works to protect the internet, open internet, promote affordable broadband deployment, among other goals. Was very active in the Internet Slowdown Day of Action that we'll hopefully hear more about today as well. And may be involved in the Jumbotron outside, but I was promised that my face will not be on the Jumbotron, so I'm hoping that's true. All right. Fair enough. Corey Wright is Director of Global Public Policy for Netflix, a company that probably at this point needs no introduction, at least not in my household. And Netflix also has had an active presence here, as we'll hear, in terms of views on how best to protect and promote the open internet, and in particular on what the scope of our new rules should be. Christopher Yu is a distinguished professor of law at the University of Pennsylvania Law School. He also directs the Center for Technology, Innovation, and Competition there, and I think has been very generous in his time in coming to the FCC and lending his expertise. I believe I saw you in a similar role at maybe a different seat in the panel last week for one of the conferences here. So thank you for continuing to bring your expertise to bear. With that, again, in alphabetical order, I'll just ask each panelist to sort of set the stage before we go into question and answer on the topic at hand, which, again, is the scope of the rules. The notion being identifying the right public policy, which was what we talked about last panel, is really just one part of the equation. It's really important that we also apply the public policy to the right set of services and in the right scope. So with that, I will turn over to you to talk to the proper scope of the rules. You can talk about all three of the points we've mentioned: specialized services, reasonable network management, internet traffic exchange, or one or two. It's up to you.
Great. Thanks, Matt. And in the absence of alphabet neutrality here today, I will try to do my best to represent the first half of the alphabet. And I can assure you that I did not pay for the prioritization of going first.
All right.
My father gave me the name, and we're born with certain advantages or disadvantages depending on how they go. So in my less than 3 minutes now, I'm going to try and just make 2 points about questions of managing traffic on the internet. The first point that I would like to make is that the internet is not a highway. It is not a road. It is an electronic communications network. And trying to decide how we should treat the internet in a regulatory structure based upon what we think about highways is not a very smart way to make public policy. And the reason I bring this up is because there's a lot of discussion that uses analogies that just do not reflect the reality of how traffic moves on the internet today. At a very simple level, the truth of how traffic moves on the internet today is that packets are routed from point A to point B, and they go through a bunch of routers and switches along the way where that happens. When there is no congestion, they move literally at the speed of light, and Einstein can explain the limits on that, but I don't think that affects consumers in a meaningful way. But when there is congestion, that's when we have issues here, which is what do you do with packets when more packets are coming into a router that then can be spit out at the other end of the router? Well, you can do one of two things. You can either randomly drop packets and then have them resent later and randomly impact applications and services and what's going on in that particular traffic stream, or you can choose intelligently based upon the kind of applications or what the consumer wants to figure out whether or not the service is going to be impacted or not. For some things, we care nothing about the short-term time impacts of the travel of our traffic. Other things, whether it's voice over IP, whether it is watching a movie, or even maybe some more important things like emergency communications or telemedicine or distance learning, we do care how those packets get there. So it is important when we look at what is reasonable in network management that we also analyze how the management is impacting the end users, the applications that people are trying to do. Then I'm going to try and make my second point in 30 seconds or less, which is that we also need to care greatly about specialized services. And we know what some of these are, like voice over IP today, but we also don't know what some of them are going to be in the future. As we move into the era of the Internet of Things, there are going to be a lot of things operating across IP networks that may not even touch human beings, but where the movement of the traffic related to that matters enormously, whether it's a smart grid, keeping the electrical grid up, or whether it is remote manufacturing controls or not. How we deal with those services and whether we can provide communication services that enable all of those things that bring an enormous amount of value to our economy in the future matters. And the Commission needs to set rules that allow specialized services to come to serve those needs, including the needs that we just don't know about today because the technology hasn't been invented yet or fully developed yet. And so we need to be expansive in what we allow to happen rather than restrictive.
Thank you. Daniel Pataki from Edno.
Thank you very much. I never knew that 3 minutes is so short. And if I don't look good, that's because of the jet lag, so I have to admit. And also, one of the panelists asked me how did you how come that you've been dragged to this, basically. And I was wondering while listening to the first panel, and maybe I'm here to listen what Europe is all about. So I thought, because there was a lot of misconception in the previous panel about, how we do things in Europe. So I thought that I would rather, in the 2.5 minutes, give you a few observations of where we come from. And first of all, I think it's very important that Europe is not the place to give lessons now. So we are really in the same debate, and maybe we are even in a more difficult problem than you are facing, but maybe we can discuss it later. Number one, my first message would be to you, FCC, and to the US, that you got it right, so don't spoil it. So this is basically, we believe that you have preserved your climate for constant investment, and this is basically because of your regulation. So we made several studies which show that Europe is lagging behind investment, and the reason for this is our regulatory policy. I was part of it for 8 years, and that fit for purpose, but it's no longer fitting for purpose for a few years. So if you would listen to me, maybe my first message would be that don't make the mistake of making a U-turn on this, because that's why you're better placed. Number two, as a former regulator, because I used to be head of European regulators too, is the more I listen to this debate in Europe and here as well, even if I wouldn't dare to give any advice, is basically look for the problem, what needs to be fixed. and look for evidence and what is the real consumer harm. Because the first time I heard about net neutrality was 10 plus years ago, back in Europe, and still after 10 years we are struggling, what this is really about. What is the definition? So some people would say that, there are more to obscure it than go into the heart of the issue. And also there's also some people rather like to define it as what they want to believe, what should be in it. But what we believe in Europe, there's a consensus emerging about what are the fixes to be done. One is there's no way, the non-discrimination, no blocking or no throttling. Everybody agrees that this is a no-go. All our telcos are on board. Second one is transparency, so full transparency for consumers. That's the second one we believe should be done. And there's the third one, which I cannot elaborate, which is, I would call it's more like a hypothetical or a speculative problem or a future potential problem of slow lane or fast lanes, and we don't believe that there should be anything done about a non-existing regulation. And maybe my third point, or third or fourth point, I would do it when I have another chance. Thank you very much.
Great, thank you. Professor Piha.
All right. 3 enormous issues in 3 minutes is cruel. Specialized services. It has shocked me for years that people who care about the open internet have largely ignored the issue of specialized services, which is at the core of this issue. There are carriers who will say that, first of all, open internet rules should not apply to specialized services, and that they should have broad latitude to decide what is and is not a specialized service, which is, in a sense, a way to opt out of the open internet rules at will. The Commission should either provide meaningful guidelines that limit what a specialized service is, or they should apply open internet rules to specialized services, or some combination if we're going to have an effect here. Second, let me talk about discrimination. Open internet rules need to prevent unreasonable discrimination. That's what we're here for. An internet access provider might use unreasonable discrimination to become a gatekeeper, for example, discriminating based on content and applications in places that would not make sense. But we must be very careful not to prevent reasonable discrimination. There's lots of things that are reasonable. One of them that I want to highlight is there is value in having different quality of service available to those applications that might want that different quality of service. And I'd hate to see regulations that prohibit that, and I'd also hate to see regulations that prohibit charging for it, or it isn't going to happen. Sometimes telling the difference between reasonable and unreasonable is figuring out who makes the choice. And if I get to choose that I want the high quality of service at the higher price or the low quality of service at the lower price, that may be okay. Whereas if the network says, my competitor can have high quality of service and I can't, now we have gatekeeper again, and there's a problem. Should rules apply beyond the last mile? The question actually concerned me because the rules, as I understood them, have always applied beyond the last mile. They apply to within the network, at least of the internet access provider, and an internet access provider has more than a last mile. There's more to the network than that. But whether they should extend to the interconnection agreements, that's new. I understand why some are arguing why they should, and I understand why some are arguing that there shouldn't. These are very complex systems. I'm concerned that we don't have enough information about them. I think the FCC needs more information to make intelligent decisions. I think some of that information needs to be reflected back to consumers, which means transparency rules may be helpful in that. I would be very nervous about anything other than transparency rules based on what is publicly known about these agreements today.
Thank you. You finished actually on time. You covered 3 big topics, and so it's impressive.
Superficiality helps.
All right. Digital compression. Matt Wood from Free Press.
One of the benefits of Title II is it allows a flat ban on inside jokes by telecom lawyers.
Oh, wow.
That's why we're fighting for it so hard. No, I mean, thank you for having me here, first of all. It will surprise no one to hear that Free Press is very concerned about the authority the Commission has and uses in this proceeding. And so 3 big topics in 3 minutes is kind of cruel, but I think we even need to take it up a level from there and first talk about the basis of the rules that the Commission may or may not adopt. Hate to be the panelist that says the topic of the panel then is premature, but I think it is in some ways tied to the authority choices that the Commission makes. And I'll talk really briefly about that after noting that we don't think Title II, the favored choice of free press and many other advocates, public interest groups, companies, millions of people, is in fact any kind of heavy-handed regulation. That's the kind of talking point that we hear all the time. Well, Title II is heavy-handed. Well, that's not actually true. We actually live with many Title II services today. I think one of the panelists on the previous panel said he lived in a Title II regime. Well, we all still do. And there's been no harm to investment or deployment from Title II that we can measure. It actually does provide the Commission with a great deal of flexibility to address these very same questions we're talking about here today. So turning then to those questions, reasonable network management is a concept that very much does fit in with the Title II standard. Is discrimination reasonable or unreasonable? I would not argue from there, as some carriers have, that the Commission is powerless under Title II to ban certain kinds of practices. But it's clear, just as the reasonable network management rules did in 2010, and just as they would in any new open internet regime, that the Commission would have some authority to pass on whether those practices were reasonable, but that carriers would be free to address the kinds of problems that Jeff mentioned earlier. When there is congestion, that's exactly what the reasonable network management rules were designed to address. Can carriers use measures to address that congestion when and where it occurs? And the answer, of course, is yes. I think, though, what we've seen over the last few years is especially wired broadband providers giving up on that congestion rationale. They've looked at their networks and said, well, they're not really congested at this place and at this time, but we still like these traffic management practices because they allow us to increase our revenues. And so we hear talk of things like two-sided markets and the kinds of specialized services that Professor Piha was talking about, and these new and innovative models that broadband ISPs promise, when in fact what we really need is a lot of the same old principles we've had. Yes, reasonable network management is allowed. Yes, certain kinds of new services could grow up. The World Wide Web is not the end of the Internet, and we shouldn't treat it as such. But there are gatekeeper problems that the Commission must be in a position to address, and we see there is no way for them to do that without a solid basis of authority to consider the questions that you've put before us on this panel. So one of the many market power issues we see is, Professor Piha called it interconnection. That's what a lot of people have called it. We actually see that as a terminating access monopoly problem, and something that we have seen abuses of in the current context, and I think that's a place to spend significant time here today. And I can stop there because I know Corey Wright may address those issues. I have a hunch.
Thanks very much, Matt. Corey, is that the plan?
I was just going to talk about, specialized services.
Great.
No, I think that Netflix's contribution to today's conversation is to try to shed some light on the role that interconnection can play in an open internet. And what do I mean when I say interconnection? Interconnection puts the inter into the internet. And in our experience, it can be used as a bottleneck for ISPs to impede their consumers' access to content. And that has led us to the conclusion that while open internet protections for the last mile are important, if interconnection isn't also included, it can be circumvented. To date, the FCC's open internet policy has really focused on an ISP's ability to slow, block, or degrade content as it travels over its network. But ISPs can also block, slow, or degrade how and whether content enters its network in the first place. And in our experience, that sort of leverage, that gatekeeper power, has manifested in the form of access fees. And in a way, when you talk about ISP gatekeeper power, interconnection is that actual gate where it's exercised. So when an ISP allows the interconnection links to its networks to congest consistently, a consumer really doesn't get the broadband access that she's been advertised, no matter how much speed she pays for on the last mile. And so I would disagree slightly with Professor Piha. I actually don't think the interconnection issue is complicated at all. It's really just an extension of the last mile power that we have always looked to curb in terms of open internet protections. In 2010, the open internet rules took a very dim view on charging for access or charging for paid prioritization over the last mile because of the harm that those charges could pose to innovation and competition on the internet. levying those same access fees at the point of interconnection is really no different. And so we think that if you're going to have open internet rules that protect innovation, protect competition, ensure that consumers can get access to the content that they are paying their internet access provider to connect them to, we think that protections also need to apply to the interconnection point to make sure that even the best last mile protections aren't circumvented.
Thank you, Corey. Now, Professor Yu, at the end of the alphabet.
Yes. Just going to show that every part is even random or first come, first serve often has systematic biases, as Julie Veach will clearly appreciate. Taking the issues, there's a lot of things that have been discussed, which I have written on, and I could talk about EU levels of competition, terminating access monopoly. I'll focus on the topics that's teed up by the questions, and we'll work the rest of this as we go. Reasonable network management. There are a lot of network management things that happen. So the University of Pennsylvania has an IT staff that's firmly committed to non-management. They prioritize two things, public safety communications and environmental controls. I would willingly pay for a better connection to the half a dozen locations I go to the most. Most often is dialing remote desktop access to my office, my email server, my bank. Most of us go to a handful of places that we go to and rely very heavily, and also with highly interactive services. And so it's an interesting question, and I think that a good framework for thinking about reasonable network management is the one originally proposed by the Commission, which is one of commercial reasonableness. I'm happy to talk about it at great length. It's used, that is a concept that is widely used in other contexts, particularly contract law contexts. And the first step is to look at industry practices as a baseline, but to maintain a degree of flexibility out of it. So it has an inherent way of looking at what other practices are going on, and I actually think it has a great deal of promise for one that will guide based on what other people are doing, but provide a good deal of flexibility for new things to happen. Specialized services. The quickest thing I can say is things like IPTV and VoLTE depend on them today. And those are core things that we're looking for. We would not have them otherwise. At the Internet Governance Forum the last week, we heard from developing countries that zero rating plans are essential for them to build out connections. For them, the quality of the connection is a second order consideration behind having a connection to begin with. And for them, anything that makes the connection cheaper is better. And that's a relevant consideration for us in areas, low income and rural areas, which are having trouble getting connections as well. It is a different sort of business plan. If you're worried about minimum standards, I would point to the non-blocking rule, as that has a minimum standard built into it. And if we're going to address that as a concern in specialized services, the framework is already there. Last point, interconnection. The thing that always struck me is the internet is a network of networks. If you measure it by what they call autonomous systems, that's what is different routing entities. There are 47,000 routing entities interconnecting through bilateral negotiations. The idea that two packets will arrive with the same speed and pay the same price blinks reality. Unless we're going to have a system where we displace that regime of bilateral negotiations with something much more regulatory, you can't do it. Second, if you get one price wrong, connections will flow, data will flow to that connection. And in fact, what we should think about this as an endogenous choice, including third-party CDNs, data centers, and in fact, it's not a standalone decision. Last point I'll make in closing. The big question to me, we've talked about permissionless innovation. The interesting question to me is, when you have a new service that was not contemplated by the previous regime, is the default answer yes or the default answer no? I would suggest that Title II, where you have to then sets up an ex-ante rules where you have to seek forbearance, makes the default answer no. An ex-post regime based on reasonableness would make the default answer yes, and that's what we need to preserve the innovation environment.
Okay, here we go. Thank you to all of the panelists for helping to keep us on schedule here. We're hoping for a lot of terrific questions from the folks here as well as the folks watching online, tweeting and emailing in. But let me kick it off with one, and Matt, let me start with something I think I heard you say, and then others might want to respond as well. You said that there's a place for reasonable network management in the FCC's policies and in our rules going forward. Could you elaborate a little bit on that? And in particular, how are we going to decide if something is reasonable or if it isn't? Do we have to say up front what we think is going to be reasonable, or is it case by case? How would you do it?
Sure. case-by-case adjudication fits very well within Title II, so I think sometimes people have suggested that, well, 706 is case-by-case and Title II is somehow prescriptive. But, of course, the way things work under Title II is people can come and file a complaint about a practice they think is unreasonable. It's just that, as we heard on the last panel, it's about where the default is. And I think Professor Yu's template there is close to right, but not entirely right. The default answer can be yes for a new service under Title II. It's just that the Commission has the ability to actually weigh in and determine if that's reasonable or not. So what makes a practice reasonable is, again, if it's actually tied to, for instance, addressing congestion when and where it happens. The case that really set us off on a lot of these discussions is Comcast blocking BitTorrent back in 2007 and 2008. And on the basis of claimed congestion, Comcast said, we're just not going to let that application work. We will maneuver to make sure that it doesn't work very well for our users. Not actually doing anything to address congestion when and where it happens. It's really a block first and ask questions later kind of approach. Instead, what Comcast moved to after they were caught doing that, and people rightly cried out about it, was they started saying, well, when and where congestion occurs in your neighborhood when a certain user is causing that congestion by using more of the pipe, if you will, than other people are, we can address that congestion then and there with measured techniques that will actually make the performance better for all. That's the kind of thing we see as reasonable network management, not claims that sender side pays models or discrimination against certain kinds of applications or just blocking certain bandwidth intensive applications up front will actually make things better, because we don't really know what we're losing out on if we take that sort of upfront ban by the carriers this time, not by the FCC.
Professor Yu, would you like to respond to that?
So the idea that Title II, which creates a set of rules, can be flexible, the answer is yes, it can be. But by this Commission's procedures, you have to notice, typically provide 60 days notice, have to have a reply comment period, there's a certain drafting period, and under the best of circumstances, we're talking about 6 months, and often with complex decisions, much, much longer. And that's the statement that it can be flexible, yes, but on what time horizon? So one of the interesting things is 2 or 3 literatures that have been lost in the shuffle. One is rules versus standards. And what we discover is rules are never as clear as we think they are, and standards are never as vague as we think they are, and how they implement. And if you want to see how reasonableness works out, all of us who are lawyers, tort is all about reasonableness. We generally have a pretty clear set of rules that we can work this out. Common laws, contract, property, all these things, they have a way of working out. What we have also, and the other literature is lost, is the codification movement in the 19th century, which is we thought everything should be rules. We never did that. And what we did is we developed a sense that there are some kinds of legal problems that lend themselves to the open texturedness of standards, and some things that are better served by clear rules, like filing dates, a bunch of things very handled by clear rules. What we're discovering in the reasonable network management context, how complex this is and the fact that it's a moving target, it seems to be one which is better appropriately handled by standards, which will be done ex post under a Title I regime.
So, Jeff, I think I heard you in your opening remarks talk about the need to address congestion. Do you think that comprises the universe of reasonable network management practices, or are there other things that, in your experience working with ISPs and working in technology, might need to be addressed?
Well, I think the flip side of dealing with congestion, and no matter how much we build the networks, there will always be congestion, because we're not going to pay what it costs to overbuild the network to such a huge extent that there's never congestion. And in wireless, it's even more complex, but that's this afternoon. The flip side of congestion management is quality of service. And quality of service is critically important if you are talking about applications that require real-time information going from point A to point B. For instance, the video we're on right now is something that real-time information makes a big difference. But there are other things like emergency communications. What if you're doing remote surgery? In fact, I was reading something on the web last night where someone insisted we must treat all traffic equally on the net because people could use remote surgery. And I was thinking, it's the exact opposite. We have to worry about the remote surgery bits, that they get there on time and correctly, or remote surgery doesn't work. And so creating quality of service is equally important as to how we manage network congestion. And they're really the same coin, just looking at it from different sides, in that At the end of the day, when you hit those points of congestion, which are the bits that are going to fall on the floor? Because bits are going to fall on the floor, and should they be the ones that need a quality of service or not? Then we can move on to the question of who should pay for that. But I think the idea that we're going to want a network that can't make those choices means that we're going to eliminate a whole bunch of applications and services from the realm of possibility. And I think that's what we have to guard against, which is why a regime of reasonable network management that looks at what is going on after the fact, that addresses what's going on and decides whether or not it's reasonable, is going to allow the flourishing of these services, rather than somebody saying, am I going to invest in creating this service when I don't know whether I'm going to be allowed to use it or not, or explain why it's valuable, beneficial, and should operate in this way.
And I think a tension, and that's a helpful point, but a tension we see both in reasonable network management and in specialized services is, on the one hand, the desire to leave room for innovation, leave room for things we haven't even thought about in terms of new applications and services, and on the other hand, wanting to avoid a loophole. I think that's something, Professor Piha, that in your comments you mentioned, wanting to close the specialized services loophole. So let's just take it from specialized services. I mean, Jeff, on the one hand, has said maintain the 2010 approach. It leaves, I think the term used was wide berth in your comments, to allow things like telemedicine and all sorts of other options. And then, Professor Piha, you've talked about closing the specialized service loophole. I mean, how do you make that balance? Because you seem to be identifying the same tension, but coming out differently in terms of where to take the risk.
Me?
Professor Piha.
Okay.
Maybe. Sorry, I didn't direct it very well.
Yeah. It is a tension. You cannot possibly decide ahead of time where all of the lines will be drawn. We can't predict that well. But I'm getting very nervous when I hear the solution is to make everything case by case. Case by case, without meaningful guidance as to what we mean, is a mandate to be arbitrary and capricious. We know that doesn't end well. And there is guidance that is possible. We need specialized services, by the way, too. I'm not saying we don't. And we need to worry about the things that you're talking about. But there are presumptions, there are guidelines we can create. And it's not just whether congestion occurs or not, it's also what you do when there is congestion. We can say, for example, there is a presumption that you cannot discriminate based on application alone. We can't say it's a hard, bright line rule because we already know there are exceptions. We know that if an application that threatens the security or the stability of the network, like a virus, should be treated differently. And there may be other exceptions to come. But we can state presumptions very clearly.
Okay. And I think Daniel Pataki from Aetna had a thought on this as well.
Yes, I think it might be the European perspective might be useful right here, because we are in kind of the same dilemma in Europe, and the legislative procedure, it's been going on for more than a year. It's much more difficult than here because it's more like a trialogue between the European Commission, the European Parliament, and Council. But the issue is the same. As I said, if you realize what is the problem to fix, and if you realize what could be the regulatory principles, then the question is what I hear now as well, whether can you be prescriptive, can you make regulation ex ante? So this is the discussion we have in Europe, and we have also the two camps, where we are, as telecom operators, we rather believe what the European Commission decided for, that was in their proposal a year ago, which is more on the principle-based. So you set out the principles, but you give big enforcement powers to NRAs. So it's a bit like case by case, but it was because they ran into the same problem. Even if they know what is the fix, it's really difficult to prescribe, and you will run up to more difficult problems in the future, because as we know, the internet, as Matt said as well, it's not over. So it's really difficult to set out in a law, even more in Europe, when it takes a few years to review a law. That how would you know what the future will bring?
And so you're saying the European Commission set up standards for judging what is an acceptable specialized service? Was that, or what a specialized service could do?
They start to have a list, but they ran into that. This is very difficult. They were opting. I think there are two major schools. One is more about you set down the principles, and then you give enforcement powers to the NRAs, and if there's a complaint, then you can act swiftly and hardly. And the other one, which is more like, you try to prescribe and write into the law all the problems what you think will occur. Mm-hmm. What I'm saying is we are more on the first school, and the Commission as well. However, the European Parliament is somehow on the second. So this whole debate is really going on in Europe. We hope that the first school will win, because otherwise I think it won't be feasible.
Okay.
Not for regulators and not for basically the stakeholders or any players in the ecosystem.
And the second approach, so the Parliament approach, would be very defined.
Defined from A to K. What are the ones which are either banned, or what are the ones which are possible?
Okay. And Professor Pia, how would you feel about a definition of specialized service? I mean, the 2010 rules had not a precise definition.
To put it mildly, the 2010 rules did not have a precise definition. I think this is a case where, actually, you can't do this in a vacuum. What the dividing line between specialized services and non-specialized services is depends on what rules apply to specialized services and what rules apply to non-specialized services. I personally would argue that you should allow greater flexibility and lighter regulation for all traffic, non-specialized, which means I can propose a fairly limited definition of what specialized services are. And in that regard, I would look at a couple of things. First of all, is the specialized service offered through an entirely separate channel? I don't mean something that had a different label, something that is a different virtual channel. I mean something that is a separate channel, and I also don't mean you dig separate trenches. A separate channel is a bright line definition, means that the utilization on channel A does not affect the performance on channel B, and the utilization on channel B does not affect the performance on channel A. They're separate then, no shared resources. If they're separate channels, I got no problem. It's a specialized service that happens to be IP-based. Now, there are some people who are going to get nervous in that I have just included, for example, some prominent cases where cable television, or what people call cable television, actually does share resources with Internet. If you are watching a pay-per-view movie, your Internet quality goes down or your throughput goes down. And, those companies are going to say, we built this thing years and years ago, you can't change the rules on us now. To which I might also say, well, that's a cable TV service. And if you want to regulate it as a cable TV service under Title VI, or you want it regulated as a telephone service, I could see treating that differently too, even though it's not a separate channel. But if you come up with something new, on a shared channel, I'd worry.
Corey, we were joking in the beginning about how you were not going to talk about specialized services, but I would love to get your views on this particular topic. And maybe we could just stick with the video example for a moment, as it's a prominent example of a specialized service. Does what Professor Pihal suggests work for you?
So it's interesting. Netflix spent a year on the Open Internet Advisory Committee following the 2010 rules, and one of the issues that the committee was tasked with was looking at this issue of specialized services. And I can say we spent 6 months laboring, trying to figure out what the heck a specialized service was. And there were really varying issues about whether or not the mantle of specialized service could be taken or thrown off in order to get a regulatory benefit or avoid a regulatory burden. So, example in the video space is if I'm an ISP and I have a TV Everywhere service, which is a service that allows you to access programming that you subscribe to through your cable bundle, but via mobile devices like tablets, or basically you can get TV everywhere. It looks a lot like over-the-top services like Netflix. It feels to consumers like an over-the-top service, and for the most part, it actually uses the same infrastructure and channels as an over-the-top service. However, some providers suggested that they could discriminatorily apply data caps to services that were unaffiliated and exempt their own TV Everywhere service from data caps because they were effectively a Title VI cable service. So this is an example, I think, when we look at specialized services, the definition may be more or less helpful, but really it's measuring the impact of that. If a specialized service can be adopted to avoid an obligation that other like services are subjected to, an ISP that can control the pipes can actually disadvantage a competitor. And so I think that sounds to me a little bit like what John has teed up. And, I think likewise, there certainly are potential benefits for specialized services. There's also the potential that those could detract investments from building out capacity in non-specialized services. It's going to be a balance. It's not clear to me that people can define specialized services with any particularity while still giving enough room to basically tweak depending on the impacts that ultimately could arise from using them.
Yeah. So, Professor, I see you'd like to respond. I'd also like to know if you have thoughts on what prior communications law or other precedent we can look to help us crack this nut on crafting a definition that maximizes the benefits of treating specialized services differently, if that's what the Commission decides to do.
Sure. Video is the great success story. And what we're discovering when we talk about specialized services, we always have a motivating use case, and right now it's video. I would say that right now, even if you want to see the confirmation of that, look at Netflix stock price, which went from 14 down to a couple billion, now 25 billion and soaring. A testament to tremendous investments they've taken and risks they've taken in content, frankly, and that's the dominant thing. But if you look at how Netflix has evolved in the way it's delivered its content, it at times has paid transit. It at times has paid third-party CDNs to do it. It at times it has an Open Connect product, which is a co-located CDN, proprietary CDN. And the Comcast Netflix agreement is through a third-party data center, but a direct interconnection. And what this strikes me is that this is a spectrum of different possible ways that you can actually bring high-volume content to the end user, and that connection is going to be made by a company based on what's cheapest given a certain technology and a given set of business relationships. And what we discover is that, in fact, the power wielded by different partners in the chain is entirely a function of how much competition they face in each one. And what I would say is, if the fact that they're getting a benefit, I think that OpenConnect's been a tremendously successful product because Netflix has taken some risks. And they did it on the hopes of getting some return. And if we then clip off that return on the back end, that's not a good sense. So we have to find a way to make sure that people get the benefit of the risks that they take. And we have to make sure that we have to understand that the choice of how they interconnect is a spectrum and is endogenous to the decisions of what they make along the way. I won't put one cautionary note out, which is video is a particular kind of use case. It's a high volume, but streaming pre-recorded video is latency tolerant. As long as it's steady, once you buffer it, you can stand it to go for a certain while. VoIP is very different. Not a lot of bandwidth by today's standards. Highly interactive, requires a different set of tolerances. I'll give you two other use cases. Google Docs, word processing. Not a lot of bandwidth, instant latencies. If you get a huge delay, you'll be very unhappy. Financial services. Millisecond latencies, perfect records, ex-post auditability. Now what's happened there? They've exited the internet. They do this entirely through private networking. So the scenario that Professor Pial is pointing out, that bandwidth is not available for sharing when they're dark, which is the genius is what's made it happen. And so we have set up a set of rules where, in fact, the failure to support specialized services is causing some people to go exit without any alternative. And that, I think, is something that the Commission has to guard against. Last answer to your direct question, Ms. Veach. Where can you look for specialized services? One of the things that we also tend to think about is through a residential lens. If we want to see how Title II works out on the business side, what we discovered is the tariffs were standardized. And businesses on the business side said, I don't need as much of A, I need more of B. And we saw a whole legacy of special access tariffs being asked from, especially of business customers and state PUCs and long-distance customers here. And whereas residences are more or less uniform on the relative scale, businesses are all over the map in terms of what they need. And so what I would look at is the legacy and the lessons we've taken from that side of the business. When we're connecting businesses to communications network, we see a tremendous heterogeneity, but we have developed tools by which we evaluate what kinds of interconnection that regulators permit and they don't.
Thank you. And Jeff was
I just
about
wanted
to
to
say
make
something.
a quick comment on the difference between consumer networks and enterprise networks in these instances when we talk about network management. All large companies heavily manage their networks, and they do that for reasons. Some is cost savings to more effectively use the resources they have, but it's also to enable the applications that they want to make sure can operate. So if you're a financial services company, you may even have separate systems for certain things. But I'll just use Cisco as an example. We have 1,000 telepresence connections across our company. In order to ensure that we have very high quality connections when we use them, we manage the traffic on our network. And in fact, there are times I can even feel that when I'm sitting at my desktop if all the telepresences are going around me. And that provides a certain quality of service that is valuable. If we want these kinds of applications to be able to operate outside of the enterprise world, and I think of things like healthcare, where you have a lot of rural applications where people don't have access to enterprise networks that can be highly managed there, we also have to allow quality of service in some form, whether it is in ordinary internet access or in specialized services, to come into the consumer world as well in order to make these things work. It's not that these applications can't work over basic internet access services. It's that you can't have the highest level of quality of service at all times that some consumers may choose to want to have. And we need to make sure that we allow that to happen and give that the possibility of going forward. Obviously, there are competition issues that come in here where people can act anti-competitively, but we have a large number of tools to deal with competition law problems rather than the question of enabling technology problems. And I think thinking about this as bringing a lot of the value of enterprise services to consumers tells you why we need a specialized services category.
Can I say to Matt, before we go to Corey?
I wanted to make a quick clarification, and I don't think I'm disagreeing with anything that Professor Yu said about interconnection, but just wanted to be clear that Netflix is not a specialized service. We are delivered over the open internet. And two, it is perfectly correct that we have paid transit providers, we have paid CDNs. We continue to do so because even though we pay terminating access ISPs for interconnection and access charges, they don't provide transit or CDN services for us. So the costs that we as a company have incurred to get our traffic to the ISP's doorstep, we still incur. And for a few ISPs, we pay an additional access charge on top of that enables the ISP to basically accept our traffic in order to deliver it to end users. And that's essentially the charge that we've raised some concerns about because the vast majority of the networks that we connect with don't charge anything. There are a handful of ISPs in the U.S. who control access to a significant number of subscribers. Denying your ability to access those end users is a really powerful hit to any business, and so our concern about access fees that are undisciplined by any competitive market forces is where we're really lodging our concerns about the interconnection issue. And to be clear, we are only talking about the point of interconnection to that terminating access ISP, which is why we really see it as just a very short extension of the last mile market power that the open internet rules have traditionally, for the past decade or more, sought to curb.
Okay. That's very helpful. And I wanted to actually, we're definitely going to return to talking about the interconnection matters. But just before we got to that, I wanted to ask Matt and bring him in on Free Press and on the specialized service discussion. And I'm not actually, it might even predate your time when you joined Free Press. It was 2010.
Okay, I take responsibility anyway.
All right. Oh, that's good. I usually do the opposite. But since it was just on the cusp of the Commission adopting the rules in December, I think just before we go into what we call sunshine, when public advocacy is no longer allowed in the week leading up to a vote, Free Press was part of a number of organizations that commented on the rumored draft at the time, and particularly on the fact that there was not a specific definition for specialized services, and raised a lot of concerns about that, and even came up with a definition, I think, saying it should be offered separate from Internet access service, like what Professor Pia just said, not replicate the functionality of a service available on the open Internet, not interfere with bandwidth allocated for Internet access, and not slow the growth of Internet access service capacity. The Commission didn't go that way. They ended up not adopting a strong definition, but saying they were going to monitor things. How do you think it all played out? I mean, with the benefit of experience from 2011 to 2014.
I do think that, there's a lot of discussions about whether the rules in 2010 did anything, and I think they did help to keep the status quo in place, but because they were under litigation threat and then in court almost immediately after they were adopted, Verizon actually tried to challenge them much earlier and then had to wait a while in order to sue, but they did so eventually. I don't know what to say about them. I think that they helped to keep what Professor Van Schevick talked about, the principles that we've had in place, even though it's been pursuant to a sort of patchwork quilt of different legal theories. It helped to keep those in place. I don't know if I'd be comfortable saying, well, they did this or that in terms of specialized services, but back to your question about what we propose as definitions for specialized services and what the Commission actually did, I think that is the big concern. We've heard about IPTV and cable and different kinds of voice offerings, and the question really is, are these specialized services eating into the bandwidth or even taking away from future growth in the bandwidth available for everything else online? Or are they, in fact, just a specialized service that we have to have because of latency concerns or remote surgery needing to be on a dedicated line or something like that? Is there a competitive impact, and are these being used as something else we weren't against, a substitute for the open Internet? Because in that case, we have real walled garden concerns. And so, yes, you could receive video or voice over a specialized service channel, but you can also get it on the open Internet. And the question is, who gets to make that choice? To Jeff's point about managing their own network, of course the company will want to manage its own network. But if a company says, we want to manage everybody's network, and we get to decide for consumers which services work and which ones don't, that's where the concern creeps in about picking winners and losers, dare I say it, not in this building, but with the big ISPs picking those winners and losers based on who they contract with and the terms of those contracts, rather than letting the openness of the Internet continue to flourish and letting the market pick those.
And I want to, Professor Piha, I want to get back to you too. We have a couple of questions from the audience and from our online participants that I want to get to the panel. Greg asks the question, are remote surgery and telemedicine straw men? These seem to be the services that everyone agrees are specialized services. I think we've heard a little bit about VoIP, and we've talked about video, but what else is out there? Or what else is on the cusp of being out there?
Well, with all due respect to Greg, let me start by disagreeing with the premise that first of all, I don't know how many people do remote surgery from their living room. It makes me nervous. But telemedicine does not have to be a specialized service. I was actually, react to some of the things I've heard here. I strongly agree that there are services like telemedicine, maybe it's Google Docs, maybe it's multiplayer gaming, that may want and benefit from better quality of service. But I do not accept that the only way to give them better quality of service is to carve this out as a specialized service and then let it be completely unregulated. I think that's, in fact, the wrong way to do it. I think we can craft rules which say we can provide a service that meets the need of telemedicine under the regular open Internet rules. And all that means is whatever arrangement was worked out that allowed me to communicate with my hospital while I was recovering from surgery is also available to somebody else for some other purpose, and if they're similarly situated at the same terms and conditions. That is not a specialized service.
Jeff?
It's the same coin. You could probably eliminate the entire concept of specialized services if you're willing to talk about basic Internet access services being a panoply of all sorts of things. So, if you're going to allow prioritization of traffic and quality of service, including, God forbid, paid prioritization, I don't understand why that would make it better or worse if somebody paid for it or didn't pay for it. The question isn't whether you want to prioritize the traffic or not. Of course we want to prioritize the traffic because there are times when that's highly valuable. Maybe surgery is a little far along, but what if I'm doing remote monitoring of patients? Someone who doesn't have to stay in the hospital but could be at home instead. But you want to have quality of service on that. It has a cost. Somebody's going to pay for it. I think that's all positive. I think it should be permitted in both instances. At times, consumers may want to buy them as a specialized services. At other times, it may just be a question of having quality of service as part of basic Internet access services. And I think we need to enable all of those things. The parade of horribles that people are worried about are all competition issues. And I think that we should separate competition problems from technology problems. And we shouldn't be banning technology because we are worried that there are some people in the marketplace who may have incentives to do things that aren't good. We have regulators to deal with those people, and we have antitrust law to deal with those people. People can file private antitrust suits. They can go to the Justice Department. They can go to the chairman here. And when those problems occur, I think they should be dealt with. But that doesn't mean we should inhibit the technology at the end of the day.
Matt.
Yeah, just quickly on that. I mean, I think I largely agree with that framework. The question is, what are people paying for? So Jeff has talked a few times about when you get to the router and you have congestion. I mean, today people would pay, one way to make your product work better and for the consumer to receive more from the Internet is to just pay for more bandwidth. But when we talk about paying to get in front of the line and to have somebody else's packets dropped further back in the queue so yours go through first, the question is, are you paying for that and allowed to pay for that because your product just won't work without it? And this is where I think a lot of these emergency services examples fit. They might not be the only ones, but it's the question of that. Does it actually need that priority to work? That's a very different question from, do I just want my service to work better than my competitors? And neither of us actually have a technical need for that prioritization. So there are some fine points to discuss here, and these are the kinds of questions, again, I think the Commission can address. Professor, you talked about rules versus standards and said rules are always too inflexible. I don't know if that's a rule or a standard. But I do think that in any case, the FCC has a role to play in making these decisions, not to slow down the technology, not to make the technology illegal, as Jeff said, but simply to have a role in deciding when it's reasonable to use it and when, in fact, it is a bottleneck, a decision by the ISP to close out competition or to dampen innovation when there are actually harmful effects from it.
To be clear, what I said is we've learned there are certain kinds of problems for which rules are more appropriate, and there are certain kinds of problems for which standards are the better way to frame a legal principle. And the question is we have to think about the texturedness, the flexibility. When I teach my class, if I had to create a rule for when my kids could leave the house, in all the exceptions and all this glory, they'll say, well, what about a fire? What about this? And all, it's very hard. And we understand that there's some situations where it lends itself better in its rules. I wanted to comment specifically about one thing which you said, which is, Julie, you asked us to can you think of specific cases? And I've thrown out a few more to broaden this out. But I actually think that's the wrong question. It's the unenvisioned case that we need to preserve out there. And what's going to happen when we have a set of rules motivated by use cases now, and then someone comes up with some new thing that requires a different set of services from the network. And there's a whole engineering literature. It's a bunch of things the Internet doesn't do particularly well. Mobility, security, multimedia distribution. It's all point-to-point right now. And there's a whole bunch of others, including everyone from Vint Cerf on down. They all say they're these things. And we have to think about no architecture is infinitely flexible. They always kind of do certain things better and certain things worse. And so the question to me is not what can we envision today, what is the thing we can't envision? And not just at the application level, at the network level too. Because we've been writing off DSL forever. And in fact, when Fios and Uverse had this fight, and Uverse has, make no mistake, a specialized service product to do video. They reserve bandwidth for one application, video, from one provider themselves. But that's what made the triple play work. And it's at a cost of $7 billion as opposed to $24 billion. And that is the question that they're facing in Europe. And right now, it's interesting. UK and Germany are on a VDSL-only strategy. And it's an astounding experiment. We found out the last time around, Fios didn't do so well. And what will happen the next round, we don't necessarily know. And with GFast coming down, we can get about 50 meg out of VDSL. GFast is offering speeds in cases up to 200 meg. And this may potentially allow us to postpone a lot of investment. So the question is, if they need to do specialized services, as was the case with Uverse, in order to make that an effective competitor, are we better off with them having to be able to forego the additional $17 billion in investment in order to deploy a 30 meg service, as opposed to doing the step that Verizon took by deploying a fiber service? It's not just the apps, it's an interaction between what the apps are doing and what the network's doing, and allowing the flexibility for people to try different things, and not any one person's conception of technologically the way either should be.
Daniel, I'd love to get your thoughts on that. I mean, earlier, I think you suggested that the FCC, that and in the U.S. in general, we should be focusing on what we see happening today and not imagining hypotheticals. Do you have a sense, either based on your own experience or the European model, of whether there are any potential harms, like potential innovation that could be stifled, that the FCC should be worried about? Or as Professor Yu suggests, are there new services out there where regulation could, and tell me if I haven't paraphrased this correctly, where regulation could potentially stifle that?
Thanks for the question. It's very difficult, because when I used to be a regulator, I was joking about that regulation is not a science, it's rather an art. Because you cannot know. So that is why there's one reason I tend to think is better when you don't know what exactly the effect will be of a regulation. You rather sit and wait. The other thing is why I would rather say that is because this is, now we are talking about regulating internet in a way, and internet was all about hands off. And all about this is innovation. This is really fast moving industry. So this is even more telling me that it should be really, really light. So it's really difficult to say what kind of innovation would come. I don't know if I knew that, I wouldn't be here. Maybe I would work in the Silicon Valley already and not be an advocate of telecom operators. So I think that is the. So it's really difficult to draw any experience there.
Is there a definition? I know in Europe, some of the industry groups, I think there's Group Digital Europe, that have come up with definitions of specialized services that are less strict than, say, what the Parliament had proposed. Do you think there's that sort of middle ground for us here in the U.S.?
I think I just have to go back to my original point, which is basically you don't have a middle ground. So it will be, so it's good to, as some beforehand, one of the panelists I think cited Bill Kenner is saying that it's one thing, if I understand well, it's one thing to agree like in a panel on theory, but the other thing is how you implement it in a regulation. So I think it's difficult once you get into the cycle of trying to sort out what is good or what is wrong and defining specialized services. Right now, as Professor Yu mentioned, it was a good example of the children. You cannot predict the future, so you cannot really predict what will happen in 2 years from now. So whether in 2 years from now you will be in a situation where then there will be another debate in a court whether this is according to your what is the interpretation of that rule for that instance. It will be very difficult to say. So what our recommendation from Brussels, the better, even if it's maybe some people will disagree, that you try to stick to the principles, but on the enforcement, in the enforcement phase, you have very important powers, swift, and you can act swiftly and very harshly.
Okay, thanks.
We've spent a lot of time on a very important topic of specialized services. I have a technical question that's probably best suited initially, at least for John. Some of the commenters have suggested that an ISP service can be viewed from two different perspectives: the perspective of the end users, and then the perspective of the edge providers. And potentially one option could be for the FCC to rely on its 706 authority as the service is provided to the end users, and maybe use Title II when looking at the service as it's provided to the edge providers. But as a technical matter, I'm curious what you think. Are there differences in how the service interacts between the ISP and the edge providers and the ISP and the end users? And are there any technical aspects of that we should be keeping in mind?
Well, first, it depends on what an edge provider is. That's not a technical term that was made up by, as part of the FCC.
Some lawyer made that up, I guess.
Always scary. If an edge provider sits on Verizon and an end user sits on Verizon, then I'm confused about what the difference is. If we imagine a world where the edge provider is somewhere far away, I can obviously technically differentiate why an end user who is attached to Verizon and an edge provider who has no technical or business relationship with Verizon, I can now very easily distinguish them. So if you want a technical difference, I'll give you that. What confuses me, though, is I don't understand how one justifies that the relationship with the edge provider is telecommunications, but the one with the end user is not. It would seem like there is, if they are different, that it would go the other way, or they would be the same. But why? I was not able to follow how you could justify that.
Well, thank you. And speaking of relationships between edge providers and ISPs, Corey, we did want to get to the topic of internet interconnection, sometimes referred to as internet traffic exchange, which I think most directly both you and Professor Piave had views on. I think, frankly, you've both agreed somewhat that it's an issue worth studying, although you come out in different places in terms of what should happen now. Maybe just to set the stage, you can give Netflix's perspective on why this is something that's something worth discussing in the context of the open internet proceeding.
Sure. And most may be familiar with some high-profile public debates that we've had with a few large ISPs about the charging of access fees to respond to requests that ISP consumers have asked for Netflix movies and TV shows. And we have, as Professor Yu alluded, developed our own content delivery network. And what that does is it basically localizes content on an ISP's network, or we'll meet them at an internet exchange point, and we literally just kind of hook our network up to the ISP's network. It has a lot of values in that it can take some traffic off the backbone, ease congestion. It ensures that delivery is more efficient because it's localized. We have implemented Open Connect with many, many ISPs here in the U.S. and globally, and usually that relationship is one called settlement-free. And settlement-free means the ISP doesn't charge us and we don't charge them. It works great. It's a frictionless way of sort of having the ISP and the edge provider plan together to scale the network appropriately so that end users requesting content don't get disappointed. Those negotiations did not go as smoothly with a few large ISPs. And the ultimate impact for consumers was that they were getting Netflix traffic in at a slow trickle for many, many months. So if you were a consumer buying a 105 megabit per second connection, you, for a substantial period of time, were getting Netflix traffic at 1.5 megabits per second. 105 megabits per second is enough capacity to stream dozens of HD video. 1.5 megabits per second starts looking like VHS or Betamax, so real old school video. We ultimately, in order to restore quality of service to our members, capitulated and paid a few ISPs. Once we paid, capacity was added in interconnection, and our data started flowing. The reason that we think that issue of interconnection is ripe for discussion here within the open internet debate is that we essentially see that point of interconnection as an extension of the last mile leverage that the net neutrality rules and policies have always sought to limit, which is it's less about the last mile or interconnection, right? It's about access to end users. If you're an online video business and you can't actually get your content to a consumer or you can't get it delivered well, your business will go downhill. And so we are very concerned about the ability of ISPs to charge these fees, particularly, as people have noted, the lack of competition among ISPs means that consumers don't have many options for switching, and even if they do, switching is really hard. So transparency and market discipline don't seem to help or advance the ability of consumers to get the product that they've paid for here. So that's kind of the crux of why we think that this is really an open internet issue.
And that's help. Thank you for laying that out so succinctly and clearly. I would just say maybe just to bring out some of the alternative views, and then we'll get to what should be done about what you've described. And these have been on the record, so they're worth bringing up here, and you can respond to them. One point that's been made is that this is largely an issue that's just really Netflix, that only Netflix has experienced. Whereas the last mile issues in the open internet are something that a broader array of entities have raised concerns about, and there have been examples of problems. And the sort of cousin of that point has been that Netflix at one time paid third-party content delivery networks like Akamai to deliver its traffic, and that system seemed to be working okay, and it was a decision by Netflix to deliver its traffic in a different way. So those are two arguments that have been raised, I think, directly in response to some of your filings.
Sure. I
should mention them and also give you a chance to respond.
Sure. So I think to the first point that this is a Netflix problem, that's certainly not true. We may be the canary in the coal mine because we're a popular service, but certainly transit providers and other CDNs have raised these issues as well. And we have been particularly vocal about our concerns about these fees, but we're by no means the only folks that have endured them. To the questions about what I usually hear is, look, Netflix has always paid. And it is true, as I alluded to before, Netflix has paid transit providers and we have paid CDNs. Those are very, very different services and functions than what we currently pay ISPs to do today. Transit is a function that brings data across the internet to multiple networks. When we pay to interconnect with an ISP, we only get to go to that ISP's network. On top of that, we are actually internalizing the cost of bringing our traffic to the ISP's door. They are charging us to open the door sufficiently to let our traffic in. Likewise, with CDN services, we did used to pay CDN services, and then we created our own CDN service. So it's not that we're no longer paying CDN services. We are internalizing the costs of running a CDN, and when we interconnect with an ISP that charges us, we are paying those access fees in addition to the costs that we incur ourselves to get that traffic to the ISP. So I think a lot of the confusion around the issue of interconnection has been confusion about what these different functions are and what we're paying for. The fact that a lot of these agreements are subject to NDA doesn't help to alleviate people's confusion, unfortunately. But I can say in sort of broad strokes, there is a stark difference between what we pay an ISP for, access charge, versus what we pay a transit or a CDN provider for.
Professor Yu?
So what's interesting is we have to remember that peering is essentially barter. If you're giving someone traffic and it costs them something, if they're also handing an equivalent amount of traffic off to you, well, you don't have to count up all the bits, just call it a wash. And they all have ratio requirements that once it gets out of whack, it's no longer a fair barter, and one of you is no longer bound by the terms of the transaction itself. There should be money changing hands. What we see often in the cases, if someone has a peering relationship and they sign up a very large customer, they're going to be out of ratio. And if that's the case, it's to be expected, usually by the peering contract itself, that there's going to be a charge. So either you have to route your traffic a different way to bring it back into ratio, or you have to start paying something. And that is the same problem, not just in a change in negotiation. If you're in a situation where you have a peering relationship and one side's business is growing, eventually that's going to take out a ratio. And the question then is, who pays for the additional bandwidth expansion? Now, if we don't allow some sort of direct interconnection agreement where the content provider whose traffic is growing pays, it's going to happen based on the last mile ISPs, all of their customers, regardless if they're subscribers to this edge service or not. One thing about having the direct interconnection, it creates a fairness issue, which is that cost is borne by the people who are deriving value from it. The other point I would make is that the negotiation is not just driven by the cost side. One of the things that I just marvel at is Netflix is a U.S. success story. But a lot of the leverage they're getting is not just from the interconnection costs, but also from their investments in content. Incredibly risky ones that have paid off in spades, and they've created a product that consumers want, and that gives them a demand-side change in the bargaining leverage, which we also don't want to thwart, because if you do that, then the motivation to do that changes. The last point I'll make is a technical one. We have a tendency to frame interconnection issues through the things we know the best. Telephone, cable, and if there's a retrans consent agreement that goes bad, a bunch of people are cut off. That's not the case typically in the internet. So Comcast has made a statement. It has 40 peering relationships and 8,000 transit relationships. So suppose that you're negotiating with Comcast and you can't get a price that you think is fair. Well, your next best option is, before you agree to the price that they want to charge, is can I route to one of their other peers and accomplish the same thing? Second, can I pay some transit? And that's the difference, and I look at the numbers and I make a decision. So the difference is we have a very much more complex interconnection architecture that creates a lot more options and frankly limits the bargaining power that Comcast has, because it's down to what the difference between the price they want to charge and what the next best alternative is. And all of a sudden we see investments happening in the core of the network like crazy, and traffic flowing in all these different ways that's creating this robust market that's been able to adjust so well that I worry that if we put too much price regulation on the interconnection space, we would lose the signals for investment and also the equilibration of content and congestion instantaneously that happens today.
Before we go to Corey, back to Corey, can I ask Professor Piha to just speak to that? Because you've, I think, if I'm remembering your comments correctly, you expressed some concern about what might be happening on interconnection, but you had a definitive view that it shouldn't be part of this, any new rules on open internet.
Well,
or if I've mischaracterized that,
what I would say is, and I talk in my comments about how it is possible that what Corey suggests is a real problem, and it is also possible that it's not. You know, I can, based on what I know, make either argument. And the fact that there was one very high-profile public dispute with one very unusual company that is like almost no other on earth does not really tell me enough one way or the other. I would also say that you say transparency hasn't worked. You can't say that because there is no transparency here. We have no idea if it would help or hurt, but we know that it's never been tried.
Consumer transparency. They can't
any
switch
transparency.
an ISP.
Nobody knows what these interconnection agreements look like except the people who participate in them. I would also, I agree with a number of the things that Chris said about the this market. Maybe it's working, maybe it's not. One thing I just want to quibble on is you focused on the ratio. And I would urge the FCC not to get lost in who is sending and who is receiving traffic, which is really not the issue. It's not that if I send you traffic, I impose costs on you. It's a placeholder for lots of other complicated things, which I'm sure I don't have time to talk about.
And I think Matt had something to add.
Well, yeah, just to pick it up there, I mean, there's often this notion that there's a lot of traffic coming to broadband subscribers and somebody has to pay for it. Okay, somebody is paying for it. As Corey has mentioned a few times, Netflix is paying for getting that traffic there, the transit piece of it, if we want to call it that. There's other kinds of relationships, but they're paying for the transportation of that traffic to get to the broadband provider's last mile network. And it's not just Netflix, though. When those kinds of providers are also coming into blocked ports or finding insufficient ports, things like cloud computing services, Amazon Web Services. Somebody said to me, maybe not an engineering term either, but they said that's the whole internet. Like, everybody uses that stuff now. So it's not just about one big company or one kind of application in video. It's really everything that comes in, either through companies like Cogent and Level 3, or else it has a direct kind of interconnection relationship with these companies today. Somebody's got to pay for that traffic, right? Well, again, people are paying for the transport. And as Corey said so well, the question is, should there be a separate fee once you've gotten to the door just to have that door opened up? As it relates to Professor Piha's point, sending is really kind of a misnomer here, because why is that traffic showing up at Comcast network? I'll keep picking on them. Not because Netflix has said, hey, it'd be a great idea to send a bunch of high-definition video to Comcast today. Let's see if they can sell it. It's not consignment, right? The reason that traffic is coming to Comcast network is because Comcast paying customers have said, we would like to stream this traffic. We would like to watch these videos. We would like to use these cloud computing services. And the problem is, I think Chairman Wheeler said this best, people should be getting what they pay for. So users are paying already. It's not like if we don't let them charge Netflix, users will have to pay. Users today do pay for that broadband capacity. And when they're getting a speed test that says, hey, you have 105 megabits per second download, and one particular kind of content or application is coming in at 1% of that speed, there's a problem. People aren't getting what they are, in fact, already paying for, and that's where broadband providers should look for recovery of those costs.
Corey, what do you think?
Well, I wanted to agree with John completely on the ratio issue and provide some examples that I think illustrate why they are, at best, an outmoded measure of value on the internet. I think the first thing is that most ISPs don't sell symmetrical connections up and downstream. So you can never be in ratio with the terminating access network. Just impossible. The other sort of more pertinent points, because some ISPs like Verizon could say, hey, we're going to now sell you a bunch of upstream capacity, even though that's not typically how consumers use their connections. Ratios tend to be applied really arbitrarily. So if an ISP subscriber uploads to a cloud-based backup service, they don't get a refund even though their ratio is greater upstream than it is downstream. And I think what that also illustrates is that ratios don't make economic sense because, to John's point, they really don't reflect the value that's derived from exchange of traffic. So we've given this example before. We could design a program where for every bit of video traffic we send, the subscriber sends us one back upstream. Now, that would be a very simple way to technically put us in ratio with the ISP, but neither we nor the ISP derives any greater value from being in ratio there. In fact, it's a really crummy and inefficient way to run a network. And I think the last part is that the greater demand for volume downstream is actually a revenue generator for ISPs. The fact that consumers value this connection so much and they are pulling content downstream, it is what is driving them to buy 105 megabit connections when they're available. And I think that's also, to Professor Yu's point, about in terms of consumers, the consumers that are buying high-speed connections because they want to access online video are actually the ones who are paying more. So it's not, your grandmother who's sending email or anything like that that's really shouldering the burden of the money that goes to build out the network. The ISP is price differentiating within its own consumers and charging more money to people who are requesting more bandwidth. That's a really efficient way of dividing subscriber base into funding upgrades that are necessary to watch more data-intensive applications.
Now, you talked a lot about the fact that there's an asymmetry in what the consumers are sold. There is some movement in the market. We're seeing, for example, Verizon with its all-fiber network. Fios is now offering symmetrical speeds up and down that are the same. If that became a common practice, would that change your views?
Doubtfully, unless they're planning on refunding to consumers who use more upstream than downstream. And as far as I can tell, that's not part of the business plan.
May I agree with Corey and John?
Yeah.
Wow. All right. This is the harmony we're looking for.
I actually think they're right. The ratio is not the right answer because if you're doing a barter exchange, that makes sense. If it costs you the same, it also has have the same value. Because and there is radical asymmetry in value. An easier case than even Netflix is advertising-supported edge providers, because you have a huge amount of value flowing in one side that's not really reflecting the other side. And so this is why we've seen advent of things like paid peering, not just from the cost side, which is what ratio measures. Although ratio even doesn't take into account the fact that a billion bits going to a last mile network delivering residential service is much more expensive than doing it to a commercial service. So that sort of sits out there as a problem. The costs are asymmetric and the revenue is asymmetric, and this is where we start to see value flowing in either directions. We can learn this from broadcast television. With an advertising-supported world, they used to pay the last mile providers, which were the broadcast stations, to terminate their traffic, that is their shows. After a while, they said, the weak ones, you're going to get paid less. And in the most extreme case, in fact, the really weak ones, you're going to have to pay us to be started the network. And that provided incentive for the broadcasters to start to improve their facilities. And then we see that the money flows in very different ways. I think it's actually very, very healthy. The other thing we have to remember is how popular zero rating systems are. This is a different model. T-Mobile customers love getting streaming music free. And the question is, and it's another way to finance a network at a time where we're looking for ways to finance build-out, and it's a creative way to actually deliver higher value. Another example, we mentioned a couple times, UK, I do want to correct one thing. BT does not actually prioritize, they actually sell wholesale. They are out of the business of doing retail. And what you see in the UK is they have 10 providers, one of which does a completely unmanaged network. This is the Alyssa Cooper's research. They showed the other 9 do different things. And they're targeting, and they have one product which my son would love. There's one that targets World of Warcraft users and delivers a very high value product to them. And as long as they have other people have options of unmanaged services, I think that that's actually a really, really attractive world in which to be. So thinking that all of it has to look exactly the same loses some consumer benefit from the fact that different people use the network in different ways.
Thank you very much. We are just about out of time. I want to close out with just one question, and maybe I'll turn back to this side of the table for the last question. So Jeff and Daniel, if there's one lesson we should learn from our experience with the rules we had on the books from 2010 until the Verizon case, what have we learned as an industry and as a country and as a public about the way the old rules worked that we should take into account now?
I actually think the rules when they were on the books and when they weren't on the books didn't really operate that much differently. And the lesson I've taken away from 10 years of experience in this space, including trying to get ISPs to do innovative services that some people may think are on the edge, is that we operate under what I call the sword of Damocles world, which is people are worried about being hit over the head by the Commission, the Congress, and the public. And if anything, there are a lot of restraints outside of the regulatory world that have been operating with and without regulation, let alone what we're going to do in regulation. And so that can inform how we want to think about adopting regulations, because it does change behavior. Daniel, any last advice for us?
Yes, I think I would rather go back to my initial remarks, which is basically from where we see from Europe, you have a thriving ecosystem, and one of the pillars of that is your regulation, which is light touch. So whatever you would do with the open internet rules, I don't use that as an opportunity to go to heavy regulation. Even Matt was saying that what they are proposing is not that, but I think that's the one last comment. And maybe another comment from an outsider on this discussion of Netflix. I think it's looking from the outside. I think this used to be a win-win situation when ISPs and Netflix working together for the benefit of the companies, but also for the consumers. So don't if there's a lesson learned from Europe as well, don't invite regulation into commercial deals whenever you can agree, because that's again it might stay for longer, and try to preserve the win-win situation. Thanks.
Thank you so much to all of our panelists. I'm going to end us now so that we can invite commerce into some of the local eateries, and everybody gets some lunch before our next panel. We will start back here promptly at 1 o'clock for the third in today's series. The topic at 1 o'clock will be enhancing transparency, and Chris Monteith and I will moderate that one before we have our panel on mobile broadband at 3 o'clock. So I hope to see everyone back at 1 o'clock. Thank you so much to all of our panelists and to everyone who participated.